10-minute rule motion. Conor McGinn.
Thank you, Mr. Speaker. I beg to move that leave be given to bring in a bill to establish a presumption against eligibility for parole in cases where a person convicted of unlawfully killing another person has not provided relevant knowledge in their possession for the purposes of facilitating the location and recovery of the victim's remains, to create a separate offence of withholding such information, to make provision about the available sentences for such an offence, and for connected purposes. Mr. Speaker, for a parent to suffer the anguish of losing a child is beyond words. But the horror of having such a loved one murdered is then surely too awful to even contemplate. So, if even possible, it is harder still to imagine the pain of being denied the chance to hold a proper funeral and lay that loved one to rest. But my constituent Mary McCourt is someone who doesn't need to imagine it, because for 28 years she has been forced to endure what she describes as the special kind of torture, knowing she could die without ever discovering where her daughter's body is, or being able to lay her daughter to rest with the dignity she deserves. Mary's daughter Helen was murdered at the age of just 22 by Ian Sims in February 1988 as she travelled home from work in the village of Billinge in my constituency. In a landmark conviction, he was found guilty of murder based on overwhelming DNA evidence, even though Helen's body was not found. For almost 3 decades, Mary has been tormented because he refuses to reveal what happened to her daughter's body. And despite this brutal act of callousness and lack of remorse, he could soon be released from jail. This is not the justice Mary and her family deserve. Killers who inflict this kind of suffering on their victims' families should not be released on parole. And that goes to the heart of the bill I bring forward today. Mr. Speaker, before I go on, I want to say something about Mary. Having had Helen taken from her in the cruelest circumstances, only to be denied the sacred right to bury her daughter, few could have found the strength to carry on, let alone mount such a formidable campaign to have the law changed so that others do not suffer in the way she has. Her quiet dignity and powerful determination is an example to us all. Our campaign for Helen's Law, led by Mary, calls on the government to introduce a no body, no parole policy for murderers. The online petition has already attracted the support of over 340,000 signatures, and in February I was honoured to accompany Mary to number 10 Downing Street to present this petition. The government responded to the overwhelming public support for the campaign by asking the Parole Board to review the guidelines around convicted murderers, and while we await the outcome of that review, it is at least welcome progress. But as Mary has so eloquently and repeatedly said, this campaign is not just about her or Helen, but about ensuring others who find themselves in such horrific circumstances do not have this added pain visited on them. Just yesterday, the Home Office revealed to me that there have been 30 murders where no body has been recovered in England and Wales since 2007 alone. But as it currently stands, the English legal system does not require a convicted murderer at the end of their determined tariff to admit guilt or reveal the location of a victim's remains before being released. Mary believes that if parole is granted to Helen's killer, then her hopes of finding her daughter will never be realised. As I have said, she is also determined that no family should live this ordeal. My bill seeks to acknowledge and in some cases mitigate the pain and distress caused to the families of missing murder victims. There are 3 main elements to it. Firstly, denying parole to murderers for as long as they refuse to disclose the whereabouts of their victims' remains. Secondly, passing a full life tariff, denying parole or release until the murderer discloses the location and enables the recovery of their victims' remains. And thirdly, applying the rarely used common law offences in murder trials without a body of preventing the burial of a corpse and conspiracy to prevent the burial of a corpse, disposing of a corpse or obstructing a coroner. In essence, the proposals are simple. If a convicted killer refuses to give information to reveal the location of a victim's body, they should not be considered eligible for parole and they should stay in prison. Effectively, it would mean a whole life tariff for murderers who refuse to disclose the location of their victims and enable their remains to be recovered to give families a chance to pay their last respects. But, Mr. Speaker, let me be clear. The modern system of parole is widely understood to involve a prisoner earning their conditional release through good behaviour. I believe in and support the rehabilitative purpose of our penal system. But while the current tariff system for the most serious crimes reflects the consensus that the majority will at some point be able to rejoin society, one is bound to ask in what sense a murderer who was content to torment the families of their victims in such a way could ever have earned their freedom. In recent years, Parliament and the legal profession has begun to take the rights of victims more seriously, and I believe this bill would be a further step towards ensuring victims are at the heart of our criminal justice system, where they should always be. Mr. Speaker, let me also make clear that the proposals contained in this bill would not affect any individual's fundamental right to maintain their innocence. The law changes I propose wouldn't in any way impinge on the rights of convicted killers to retain full access and a full recourse to the appeals process. It is worth noting, however, that in the case of Helen McCourt's killer, his guilt has only been further confirmed at every single appeal stage because of enhanced DNA evidence against him. I should also say that my bill will have no impact on the work of the Independent Commission for the location of victims' remains in relation to those referred to as the disappeared, nor would it impact on the arrangements set out in relation to sentencing for offences committed during the Troubles, or indeed any future arrangements on addressing the legacy of the past in Northern Ireland. But I do want to acknowledge, however, that the pain and anguish felt by the families of the disappeared is the same as any family who has lost a loved one in such awful circumstances.
That's right.
We are not alone in this country in seeking to find a workable legal solution. In Australia, no body, no parole laws have already been passed at state level and are being examined at federal level. Quite simply, the introduction of Helens Law is the only chance the McCourts and families like them have of securing some peace and the justice they deserve. And I want to acknowledge some of those families who are visiting Parliament today to attend this debate. Sheila Dolton and her daughter Nina, their son and brother Jonathan was murdered in 2004. The family have continually written to his killer begging for information about their son's body, but have received no reply. Sam Gillingham, who was just 16 when her mum Carol Packman disappeared from the family home in Bournemouth in 1985. Tracy Richardson, whose mum Michelle Gunshin vanished in November 2004 while working at the NEC in Birmingham. Sadly, this bill comes too late for Winnie Johnson, who went to her grave never knowing where Moore's murderers Ian Brady and Myra Hindley buried her 12-year-old son, Keith Bennett. But there is still time for Mary McCourt and other grieving mothers like Joan Morstan and Jean Taylor, who also saw their children's killers go to jail without revealing where their victims' bodies lay. Denying a final resting place is perhaps the last heinous act by killers who have no place in a civilised society. The agony and torment caused to those who cannot lay a murdered loved one to rest is incalculable. The families of victims expect quite rightly the law to act in their favour, instead of the justice system rewarding killers who decide to remain silent with parole. For those who have had to face the loss of a loved one at the hands of a callous murderer, there is nothing we can do to make up for their loss. But if there is a way to help them receive the justice they deserve, then we must take it. And if there is a way to compel those who have committed the most awful crimes to assist in this task, we must do it. And most importantly, Mr. Speaker, if there is a way to ensure that no family has to endure the suffering that Mary McCourt and hers and so many others have, then we, in this of all places, have a duty to act.
Order. The question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Tom Tugendhat, George Howarth, Siobhan McDonough, Tom Elliott, Vernon Coker, Mary Rimmer, Nuz Gani, Sir Geoffrey Donaldson, Carol Monaghan, Diana Johnson, Alan Campbell and myself, sir.
Conor McGinn.
Unlawful Killing, Recovery of Remains Bill.
Second reading what day?
Friday the 3rd of February 2017.
Friday the 3rd of February 2017. Thank you.